Hi everyone, my name is Jack Wang. I am currently enrolled in the second year of the Master of Law Judicial Division program at the NCTU Academy of Law. Today, I would like to use some time to present my presentation on Vietnam's revision proposal to the IP chapter of the Trans-Pacific Partnership, TPP. I'm very regretful that I could not be here today because I'm on a business trip to the US. However, my presentations will cover all the questions and answers that you may possibly have, and if you have any further questions, you may feel free to contact me in person. Okay, first of all, we would like to start from the introduction of the TPP. The Trans-Pacific Partnership, also known as the TPP, is a proposed provisional administrative and venture settlement, and that 12 nations all through the Asia-Pacific district have partaken in arrangement to this TPP agreement, which Vietnam is also one of the main players of this instrument. Although the instrument is almost coming to a close in 2015, there are still many issues within the instrument that would detrimentally harm Vietnam's economy as well as the well-being of the Vietnamese people. And here we would like to give you a brief introduction on Vietnam's IP conditions. Vietnam joined the WTO in 2007. Then, Vietnam had authorized new laws and regulations in order to strengthen the protection of intellectual property so that it could be part of the whole group, which is why Vietnam already adopted TRIPS into its legal enactment. There are currently 3 types of IP in Vietnam, which are copyrights, industrial property rights, including patents, utility solution, industrial design and trademark, and also plant variety. Besides WTO, Vietnam is also a party to the following community, which we hereby know as the Paris Convention, the Madrid Agreement, Rome Convention, the Patent Cooperation Treaty, International Convention for the Protection of New Variety of Plants, TRIPS, and the Berne Convention. Because of time issues, we will not go through the details of each and every IP law. We will now go to the effect on the TPP IP chapter. The IP chapter is one of the major chapters in the TPP instrument. However, a lot of questions still remain despite the fact that many countries have been negotiating this topic for several years. The TPP IP chapter would definitely pose great challenge that will cause adverse and terrible impact on Vietnamese population. The IP chapter could also harm consumers of other signatory countries, not just Vietnam, even though the income and living standards are much higher than Vietnam. The first major effect would be to expand the pharmaceutical patenting and create new drug monopolies. Patent protection for new forms and use of methods in Vietnam has long been an issue which is troublesome. The IP chapter would extend patent protection to medical uses in existing medicine, thereby perpetuating patent monopolies, even in the absence of any significant therapeutic advance. This progressive broadening of patentability would result in more evergreening patents being granted to originator pharmaceutical companies. This will really cause a lot of effect to the people in Vietnam because most of the people here are peasants and they will not have enough resources or enough monetary support to have access to better medicine. And with this kind of mechanism, the protection of the people's health will be terribly affected. The second one would be the patent protection on diagnostic, therapeutic, and surgical methods. Vietnam and many other countries exclude diagnostic, therapeutic, and surgical methods from patentability to ensure that accepted standard of care are available to patients. But now, in this TPP IP chapter, this kind of protection will not be allowed, and then the great population of Vietnam will be in jeopardy because they will not be able to have access to appropriate medical resources that are previously provided to them. Also, the scope of industrial applications is also a major question. The standard of specific, substantial, and credible utility in the IP chapter is more lenient than the industrial application standard used by Vietnam and many other countries. The IP chapter would require Vietnam to adopt the broader US standard, leading to patenting of inventions that might be considered more ideas than actual products or production processes, which will really have an adverse impact on Vietnam industry. The second effect would be eliminating safeguard against undeserved patent. Pre-patent opposition by third-party mechanism will be wiped out from the TPP IP chapter, which is a mechanism that Vietnam and many other countries usually have. Without this mechanism, the IP chapter, by eliminating the pre-grant opposition, will increase the likelihood of unwarranted drug monopolies. This will also likely increase the number of post-grant cases before the courts, rising the cost of administrating Vietnam's patent system. The third effect will be to favor big pharmaceutical companies in court. The reason why the major big pharmaceutical companies will be in favor is because there is a presumption of patent availability clause inside the TPP IP chapter. There is no presumption of patent validity in Vietnam. However, in the TPP IP chapter, all patents generally are presumed to be valid. Therefore, the judicial and administrative presumption of patent validity gives rise to costly and one-sided court procedures and make it harder to challenge even weak patents, which will adversely affect Vietnamese industry interests. Also, there are damages as value submitted by right holders. The Vietnamese law set clear standards for calculation of compensatory damages. In practice, Vietnamese courts often calculate damages based on the plaintiff's lost sale or the damages prost from the infringing activity. However, the IP chapter would require courts to consider suggested retail price or other measures of value submitted by the right holder. Calculations submitted by a right holder may turn out to be inflated or otherwise inaccurate and higher than existing retail prices, which is also adversely impacting the Vietnamese public in general. Besides the above adverse impacts, there are also other influences that the TPP IP chapter may impose in Vietnam. The IP chapter also leaves placeholders for several controversial provisions that may require changes to Vietnamese law and risk to access to medicine. These include patent term extensions, data exclusivity, patent registration linkage, especially for patent registration linkage, which we will further discuss in the following topics. Now we move to the risk caused by the IP chapter. While fully aware of the necessity and benefits of IP rights protecting and promoting innovation and economic development, and thus in favor of reasonable IP protections in Vietnam, as well as Vietnam's participation to WIPO treaties by appropriate schedules, we are seriously concerned that the enhancement of IP right holders and level or lowering IP right eligibility conditions, especially in patent and data and exclusivity regarding pharmaceutics, shall prevent any efforts in increased access to this kind of products that are crucial in protecting human health and life in Vietnam as well as other countries. At least for Vietnam, this perspective is unacceptable both from moral and legal points of view. According to a WHO report in Vietnam, patients actually pay 46.58 times the international reference prices for innovator brands and 11.41 times for the lowest priced together, while Vietnam has just graduated from the low-income country. Too high priced medicine is the main reason leading to too low percentage of access to medicine in Vietnam, which is a major influence on the Vietnamese public if they may be deprived of their access to medicine. With this fact that a large part of patients are or about in working age, business and the whole society will be adversely affected. In patent and data exclusivity regarding agrochemical, geographical indications, and copyrights, that will draw back Vietnam's production in general and especially in agriculture. As Vietnam is a backward agriculture country which has undergone a long and difficult period of war and embargo, millions of Vietnamese farmers are still spending a large part of production costs in fertilizers, plant protection chemicals, and veterinary products. Higher protection on patent and data exclusivity means rising agricultural price, preventing any possibility to lower agricultural production costs and thus crushing all chances and ameliorating income of 69.4%. Vietnamese population who are living on agricultural productions and at household size. Similarly, this shall deprive any industries in Vietnam from the opportunity to modernize their current backward production because of too high-priced technology. Also, this might worsen the IP right violation situation in Vietnam and thus do more harm to right holders. Because Vietnam has been facing with difficulties in implementing the TRIPS standards, which are already high as proposed by developed countries, so any attempt to heighten current IP standards might be disabled in spite of Vietnam's government's goodwill. In this context, the right holders' benefits shall definitely be damaged. Thus, concentrating on proposals to enhance the enforcement of IP rights in Vietnam will be the best solution. To sum up the three major effects that the IP chapter would bring can be simplified as follows. First one would be undermining quality of life. Second one would be limiting income of poor people. The third one would be aggravate social gaps and instability. It is believed that these are the most concerns of TPP negotiations, and we as a Vietnamese government will not allow this to happen in order to detriment the livelihood and well-being of our citizens. Therefore, we come here to propose the following recommendations for the IP chapter. While there is most likely a portion of most notably and bad component of the IP chapter, protected innovation, part have been made moderated along the way. The last result is still not to exact a calamity in worldwide well-being terms. A number of the starting harmful procurement initially proposed still remains in the contents. These incorporate, among others, license for new use and new routine for utilizing existing items, a low imaginative edge for issuing licenses, patent terms augmentation for postponements in giving license or handling showcasing endorsement applications, no less than 5 years of information security for new pharmaceutical items, and patent linkage procurement liable to bring about deferral and advertising endorsement for generics. Without precedent for the exchange understanding, the TPP likewise incorporates a procurement obligation notions to give at least 5 years business sector selectiveness for biologics. At times, the IP chapter has been relaxed. For instance, the first IP proportionation looked to make it compulsory for nations to give license to new structures, new uses, and new technology. The necessity to give license to new and the last TPP content obliged nations to give license to no less than one of the company, new employment of a new item, new routines for utilizing a new item, or new procurement of utilizing new known items. The patent term augmentation and patent linkage procedure of utilizing a known item have likely been made more adaptable and less comprehensive prior draft. With the above concerns, the Vietnam authorities would like to draw the attention to the following proposals. The first proposal will be to delete the enlargement of patentability scope to new items, especially new use, plants, animals, and there should be no extension of patent lifespan and no lowering patent eligibility conditions, with severe consequences on price of these items to people in income, life, and health. The proposed measures in draft go against the world tendency, where governments are seeking hard to renegotiate for a lower protection of IP right holders regarding pharmaceutical and agrochemical. These measures conflict also to the TRIPS exceptions that the US itself agreed to, according to which patent is used to protect only real innovations that are meaningful and contribute to development of humankind and the society, but not to unreasonable prevention of such developments. The second recommendation will be to revise the protection of geographical indicators under trademark or trademark similar mechanisms. Geographic indicators has been a specific IP right, characterized by the fact that this kind of IP property does not belong to an individual person, but a community as a whole, and not only to income but also the community's spiritual and social life, which is a very important aspect of Vietnamese culture. Under this condition, protecting geographic indicators under trademark or trademark similar mechanisms shall nullify this core character of geographic indicators at the detriment of fragile community living in these geographic indicators. The third proposal will be to revise the extension of copyright terms nor copyright protection scope, technological protection measures, TPMs. Drafted measures seeking for copyright term expansion shall, on one hand, adversely and directly affect the cost and knowledge access of the public. And as the major public of Vietnamese are peasants and are undereducated, we believe that a freely accessible will be able to enhance the Vietnamese people's educational standards. And in Vietnam, a backward development country with high demands for the world diverse knowledge to develop, these impact cannot be neglected. Now that we have moved to the future IP landscape in Vietnam, if the above proposals cannot be implemented, then the changes will happen to Vietnam. However, it is our endeavor to do our best to persuade other delegates in order to revise this instrument and in order to bring prosperity and well-being. This is my presentation on the standpoint of Vietnam. Thank you for listening and welcome any more questions.